Today, we will discuss the tax considerations for cooperative business structures. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, as well as a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my law practice. Our firm website is www.cummings.law. Cooperative business structures, often simply referred to as cooperatives or co-ops, are unique entities that prioritize the needs and goals of their owners over profit maximization. These structures are owned and operated by a group of individuals for their mutual benefit. While cooperatives can take various forms, including worker cooperatives, consumer cooperatives, and producer cooperatives, not to mention cooperatives formed for the purpose of managing a multifamily building, as is fairly common here in Florida, although less common than they once were. I digress. These all share the common principle of democratic governance, typically adhering to the one member or one owner, one vote rule. The cooperative model is particularly appealing to those seeking a more equitable and participatory business framework. However, the tax implications of operating a cooperative can be complex and require careful advanced planning and consideration. It is crucial for those involved in or considering forming a cooperative to understand these tax nuances to ensure compliance and to optimize their financial outcomes. One of the primary tax considerations for cooperatives is the potential for tax exemptions. Certain cooperatives may qualify for tax exempt status under Section 501c12 of the Internal Revenue Code. This section applies to cooperatives that operate on a mutual or cooperative basis, providing services to their members. To qualify, at least 85% of the cooperative's income must come from its members. It is essential to note that not all cooperatives are eligible for tax exempt status. The eligibility requirements are stringent, and failing to meet them can result in significant tax liabilities. Therefore, it is advisable for cooperatives to consult with an experienced attorney and CPA to determine their eligibility and navigate the application process for tax exempt status. Cooperatives often distribute profits to their members in the form of patronage dividends. These dividends are typically based upon the amount of business each member conducts with the cooperative. From a tax perspective, patronage dividends can be a double-edged sword. While they are generally deductible by the cooperative, they are taxable income for the members receiving them. The intricacies of these dividends require careful management to ensure compliance with tax law. Cooperatives must issue Form 1099-PATR to members who receive patronage dividends, and members must report these dividends on their tax returns. Understanding the timing and method of these distributions is crucial, as improper handling can lead to unintended tax consequences. Subchapter T, as in Tom, of the Internal Revenue Code specifically addresses the taxation of cooperatives. This section allows cooperatives to exclude certain income from taxation, primarily income distributed to members as patronage dividends. However, Subchapter T also imposes stringent requirements and limitations that cooperatives must observe in order to benefit from these tax provisions. For cooperatives, compliance with Subchapter T is not optional, but mandatory. The complexities involved in meeting these ongoing requirements necessitate the experience of an attorney and CPA who, frankly, is not a novice in this unique area of law. These professionals can provide guidance on how to structure operations and financial reporting to align with Subchapter T, ensuring that the cooperative maximizes its advantages while remaining compliant with federal and state law. In addition to federal tax considerations, as I alluded just a moment ago, cooperatives must also navigate state-level tax obligations in many states. State tax laws can vary significantly, and some states offer additional tax incentives or exemptions for cooperatives. Understanding these state-specific provisions is imperative for cooperatives seeking to optimize their tax and financial position. Cooperatives must be diligent in researching the tax laws of the states in which they operate. This includes understanding the requirements for state income tax, sales tax, and any other applicable tax laws. Engaging with a knowledgeable attorney and CPA can provide invaluable guidance in navigating the complexities of state tax laws, helping to ensure compliance and identifying potential tax savings opportunities. There are several common misconceptions about the taxation of cooperatives that can lead to costly mistakes. One misconception is that all cooperatives automatically qualify for tax-exempt status. This is not the case. As previously discussed, the eligibility criteria for tax exemption are specific, and not all cooperatives will satisfy them. Another misconception is that patronage dividends are always tax-free. While they are deductible for the cooperative, as I said earlier, they are also taxable income for the members. Misunderstanding this can result in members facing unexpected tax liabilities. Therefore, it is crucial for cooperative members and management to have a clear understanding of these tax implications to avoid surprises and ensure accurate and consistent tax reporting. Given the complexity of tax considerations for cooperative business structures, seeking professional guidance is not merely advisable, but essential. An experienced attorney and CPA can provide the expertise and guidance necessary to navigate this intricate and nuanced tax landscape, thereby helping to ensure compliance and attaining the best possible tax outcome. Professional guidance can also assist cooperatives in understanding their eligibility for tax exemptions, as I mentioned before, properly managing those dividends and complying with both federal and state law, including tax law. By engaging with professionals, cooperatives can focus on their primary mission of serving their members while confidently managing their tax obligations. Cooperative business structures offer a unique and equitable approach to business, prioritizing member needs and democratic governance. However, tax considerations associated with cooperatives are complex and require careful attention. From understanding tax exemptions and patronage dividends to navigating Subchapter T and state tax laws, cooperatives must be diligent in managing their tax obligations. By dispelling common misconceptions and seeking the guidance of an experienced professional team, cooperatives can ensure compliance and navigate a course to the best possible outcome. The complexities inherent in cooperative taxation underscore the importance of professional expertise. Again, my name is Chad Cummings, and I hope you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier videos, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a telephone consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.